by our next submitter on the Agreement for Climate Change, Trade and Sustainability. Thanks. Good morning, Mr. Solomon. Can you hear us?
Yes, I can hear you. Can you hear me?
Yes, we can hear you. Thank you very much.
Kia ora koutou.
Received your written submission, and we have 10 minutes set down for you to speak to that submission.
Thank you.
Thank you.
Thank you very much. So yeah, look, just briefly, Maui Solomon, background in law. I was the senior legal counsel for the Y262 claim for about 20 years, and part of that claim was for Māori to have a greater voice and representation in the development, implementation of international agreements that New Zealand's entering into. Been a CEO and currently a regenerative sheep and cattle farmer, and got a native plant nursery here and planting up to 100,000 native trees on our Huno Hinu family land. So yeah, got a bit of experience in terms of international issues and trade and so on and so forth. Been on the Fisheries Commission, but I'm here in my capacity today as a pūkenga advisor to Ngā Toki Whakarururanga. And just a little bit about Ngā Toki Whakarururanga. You know, this is a Māori nationally mandated body that arose out of the claim that went to the Waitangi Tribunal, the Y2522 claim, in opposition to the TPPA. And so Ngā Toki was formed out of that, and so we have out of that mediation agreement. So it's specifically mandated to uphold the tenets of the Treaty of Waitangi and he whakaputanga o ngā rangatiratanga. And we engage with MFAT across a broad spectrum of the development of international free trade agreements, protocols, you name it. And I just want to endorse and support the submissions of the former presenter, the last presenter, Professor Jane Kelsey, who's also a member of Ngā Toki Whakarururanga. But look, I just I take it the submission we've made will be taken as read, but I want to give the Select Committee a bit of a brief background on Māori efforts in the international treaty and trade making space. Some may know, some may not, but I think it's relevant to this kōrero today because Māori have been involved in this space, you know, even before the treaty was signed. So, you know, really, I want to take you back to 1835, the He Whakaputanga Declaration of Independence that was signed by the northern chiefs and tribes, and that declared their sovereignty. It was something that was recognised by King William back in the day, and it was specifically entered into. One of the key reasons was to enable Māori to trade internationally under their own flag, and that was a flag that was endorsed by King William himself. So Māori have been trading long before this current nation state was formed. And then, of course, under the Treaty of Waitangi in 1840, and that guaranteed to Māori their tino rangatiratanga. And as I discussed in a previous submission this morning to the Justice Select Committee on the Treaty Principles Bill, tino rangatiratanga really equates to sovereignty. And the chiefs and tribes did not cede their sovereignty in 1840. Having just declared it in 1835, there's no way those august and fearsome rangatira 5 years later were going to cede sovereignty to a lady sitting in a palace on the other side of the planet. That just didn't happen. So the Treaty of Waitangi also guaranteed to Māori their continued right to make international treaties and continue to trade in their own right. So we all know the history, the sad history of our country, which saw the treaty just pretty much abandoned and carboned and literally gnawed by rats and mice and declared a simple nullity. Māori were marginalised on their own land, so prevented from access to banking and finance and trade activities. So we were marginalised people in our own country and our own land. That's the facts. That's the reality. 1991, the Y262 claim was filed, and as I referred to, that had a significant international component. And in fact, we sought urgency on that claim in 1994 when the GATT TRIPS bill was first introduced into Parliament. And, that we advocated back then for a treaty protection mechanism to be incorporated into that bill. Tau Henare was then the Minister of Māori Affairs, and he put that to the House. It was lost by 2 votes, 42 to 40, just 2 votes that would have actually entrenched Te Treaty o Waitangi protection mechanisms into the legislation. However, Māori did not give up. Māori never give up and continued to protest in relation to the Mai Agreement, TPPA, etc. Now, Māori aren't just protesting against trade and commerce. We've been traders and commercial people might unknow, but there's the other aspect. With rights come obligations, and Māori put their obligations ahead of their rights. And so the right of te tao, the right of papatunuku, the right of ranginui, the right of tangaroa, all of those things absolutely paramount. The difficulty with agreements these days, they put profit ahead of papatunuku and people. And, the Māori voice is very important. The Indigenous voice is very important in this space, but is being marginalised, is being excluded. And in fact, this ACCTS, or the ACTS agreement, is yet another example of that. So I just, yes, Ngā Toki Whakarururanga had very limited access to some of those papers, but the deal was done before we saw it. It was all shrouded under a cloak of confidentiality and secrecy. But, it's called the Agreement for Climate Change, Trade and Sustainability. But really, come on, there's not, it's not really addressing the core issues with the climate crisis. And I use that deliberately. We're in a crisis now. That's a scientific fact. And this is just a free trade agreement dressed up in green drag, to be honest. And so, call it for what it is. It's a trade agreement. And actually, at least the minister, Todd McClay, when he signed the agreement and the press releases I've read, acknowledges, look, it's a trade agreement. The climate stuff is little garnishing on the side of a plate, really. And that's why the Māori voice is needed. Māori need to have a seat at this table. They need to be at the negotiating table as well in these things. That's the right guaranteed under Te Treaty o Waitangi. And in fact, the Waitangi Tribunal in Y262 said on some issues, Māori should have the front seat at the table. But the Māori voice is not being heard. And if anything, it's being filtered through a process that doesn't understand anything about the Māori voice or the Indigenous voice. And, there are Māori. What about the Indigenous people in Costa Rica and in Iceland? And I'm not sure if there are any Indigenous people in Switzerland, but so, that I'm just drawing that to the committee's attention. What else have I got here? Look, it's really difficult, to reconcile this this agreement with this government's agenda to use the word of Shane Jones. And I know Shane, I was on the Fisheries Commission with him. you know, and borrowing the term of President Trump, drill, baby, drill. How can you reconcile, you know, this with the, you know, the intention to drill, continue to drill for oil and gas and coal and those sorts of things when they're making massive adverse impacts on the environment? Just doesn't make sense. Doesn't make sense.
Very good. All right. Look, unfortunately, that brings us to the end of our time allocated for your submission today, but appreciate your view.
Is that 10 minutes already?
It is. It's 11 actually.
Come on.
But,
I thought you fellas were running behind schedule, I was told. You just don't want to hear my voice.
we've given you 11 minutes on a 10-minute
Have you?
item, so certainly
Oh,
appreciate
mate,
your
I really
contributions.
appreciate that. Thank you so much.
All right. You're welcome. Thank you very much.
Thank you.
Do you know that there's a timer?
All right.